to be the implication of your position is that both clear notice and consent, this court has said time and time again, are required for states to be bound. And you're saying neither of those apply when it comes to state employees.
So I guess I should clarify my answer that I do think it depends on what power the court relies. I think if the court were to say only the spending clause, then I do think that you would have to have consent of the state official, and I do think we have that here.
Let's back up. We're talking about a spending power statute, okay? And everybody has to agree, I think, that consent and notice are required for a state to be bound, right?
Yes.
And are you saying those are or are not required for the state employee to be bound?
So under the spending clause, I think that the sort of privity argument that we've been talking about today.
So no is the answer, because it works for the state, and because the state employs these individuals, they're necessarily bound.
I do think that's right, and I think that's.
So no consent and no notice is required for the employees. That has to be the logic of your view.
I think not as a formal matter in terms of under the spending clause, but I think the reason that this is such an easy case under either the spending clause. What do we do if
that's true? And I think it has to be. You're right. And I appreciate the candor. With the fact this court has always said that contract is the analogy, and it's certainly true that an agent is liable to his principal for violating the principal's rules. Here, the employee to the state. But it has never been the case, well, never may be strong, but certainly if I look at the restatement, an agent isn't responsible to a third party with whom the principal has a contract. Privity doesn't run like that. It runs between the principal and the agent, not a third party. What do you do about that?
Yes, Justice Gorsuch. Well, I would strongly resist that the contract analogy applies to answer every question that arises in spending clause
That's
legislation.
an answer. It's just ignore this contract analogy.
Well, I think that I think what the court's cases say is that the contract analogy is important for purposes of determining notice. It's did
notice
the recipient
and consent, yeah.
Did the recipient have notice? I think here it makes it an easier case under the spending clause, unlike all of the cases where the court has considered, like in Medina.
But you're asking us to ignore contract principles when it comes to the employees, right? I mean, that has to be right.
No, we just don't think that the contract analogy answers the question. We think the court needs to sort of tick through the constitutional analysis and ask, is this a necessary and proper means of enforcing the substantive RLUIPA condition? And we think it is.
We have to look outside the contract analogy because it wouldn't get to the employee here. It wouldn't. I mean, there's no privity between the employee and the federal government.
There is not. But again, the necessary and proper clause gives Congress the power to enforce a condition that's validly imposed. So once we have a valid condition that has been imposed and to which the state consented, surely Congress can take the half step further to enforce that condition against the people who are most likely to violate it.
No, Ms. Baird.